I, k.v.Setti, lecturer in PSR Law College, Kakinada, affiliated to Nanna University, Rajamahendravaram, Andhra Pradesh. I teach administrative law. Today's topic is evolution, nature and scope of administration, administrative law and definition. Today, administrative law has become one of the most important branch of public law. The powers of the administrative authorities are constantly increasing. Disputes between the state and the individual are also rapidly increasing. More than 50% of the current decisions of the Supreme Court involve judicial review of administrative actions. Administrative law deals with not only the powers of the public authorities but also its liabilities. It is now looked as an instrument which controls the exercise of administrative powers. The volume of delegated legislation made by the executive in a year is much larger than the statutes made by the legislatures. The establishment of special tribunals is on the increase and the disposal of the cases by such tribunals at a far faster rate has proved more satisfactory than the disposal of cases by the ordinary courts. Administrative law has therefore assumed wider dimensions of the public importance. Even though administrative law is as old as the executive government, it has gained recognized and developed as an independent branch of public law only in the present century. It is most outstanding legal development. Definition of administrative law. Administrative law is the law relating to the public administration. British jurist and constitutional theorist k.v.Setti has defined administrative law as that portion of the legal system which defines the rights and liabilities of private individuals in their dealings with public officials. British prominent educator who served as the Vice Chancellor of Cambridge University, Jennings, has defined administrative law as the law relating to the administration. It determines the organization, powers of administration and duties of authorities. U.S. scholar K.C. Davis defines administrative law is a law that concerns the power and procedure of administration agencies, especially the law governing judicial review of administration. It studies the law made by as well as the law which contains administration. Scope of public administration. The policy of laissez-faire have changed and the activities of government is not restricted till the defense and justice system. Hence, this branch of study is important to govern the functions of the administrative agencies. The judicial system was not very efficiently handling the burning issues of lockouts and strikes, also because it is overburdened with the current social problem. Hence, labor courts and tribunals are created to share the burden. It was difficult for the legislature to make detailed rules and procedure for the administrative function. Hence, it was required to delegate some powers to the administrative authorities. Administrative tribunals are not bound by rules of evidence and procedure, helping them take the practical approach and make speedy decisions. Administrative authorities can take preventive measures. The importance of administrative law. It aims to keep the governmental powers in control. It protects the private right of the individual. Today, the state is protector, provider, entrepreneur, regulator. Tribunalization and delegated legislation are effective weapons in administrative law. It helps to strike a balance between individual right and public interest. The nature of administrative law. It is not codified law. It is a legitimate law. It is branch of a public law. Relation with constitutional law, administrative law was still recently considered as a part of constitutional law. Early English writers held the view that it is logically impossible to distinguish administrative law from constitutional law, and all attempts to do so were only artificial, because both are concerned with functions of the government and are part of public law. Administrative law is based on a well-known legal maxim called ubi jus ibi remedium, means wherever there is a right, there is a remedy. Characteristics of administrative law. Number one, administrative law determines as to whom are the administrative authorities. 2. It decides the power of administrative authorities. Number 3. It prescribes the limitation for the exercise of such powers. Number 4. It prescribes the ways by which administrative can be controlled. Now, 5th point. It prescribes the procedures to be followed by the administrative authorities in its functions. 6th point. It prescribes the remedies available to a person affected by administrative actions. The reasons for the growth of administrative law. The first and the foremost reason for the growth of administrative law is the change in the government's philosophy from laissez-faire to the social welfare state, which resulted into an enormous increase of government functions. Laissez-faire means individualism, self-help, minimum government control, and maximum free entrepreneur. According to this doctrine, the management of social and economic life of the people was never regarded as government's responsibility. Social welfare state means a state which promotes social economic welfare of the state. When India got independence, our constitution also adopted the philosophy of social welfare state with the aim of securing all the citizens social, economic and political justice, liberty of thought, expression and quality of status. Sources of administration. The sources of administrative law is precedings, means the ratio of judicial decision. It develops upon the judgments made by the judiciary. And another source of administrative law is constitution. Through the amendments of the constitution, day by day necessities Constitution amendment also a source of growth of administrative law. The third source of the administrative law is statutes. In the situation prevails in the society, the legislature has to make the statutes to fulfill that necessity. The central or state time to time making laws, whether it is central legislation, state legislation, or municipal legislation, whatever it may be, they are making statutes. It is also one of the source of development of administrative law. The fourth source of administrative law is reports of the committees or commissions. According to the necessity, the committees of Parliament or Assembly may be appointing, or commissions also appointing as such. Suppose if an important issue is prevailing in society, whether it is burning or anything, the governments appointing committees to inquire it and submit the reports. Likewise, commissions also appointing by the legislative authorities or bureaucracy. The commissions also has to be inquired into that particular aspect and should be submitted. It is also the main source of development of administrative law.